I'm Astley. I'm the developer of the product that we're going to show you here today. For those of you who are live here, this is the second time I've done one of these webinars, and so because I'm trying to watch the screen and present to the people who are live, it can get a little bit awkward with eye contact and stuff like that, but we'll do the best we can. For those who are on the webinar, even if you have a microphone on your machine, we've muted everybody's mics, so you should be able to hear me, but you can't say anything back using your microphone. If you have questions, or if you want me to review something again, or in the case of last time we did this, if the audio cuts out, for those on the web, just pull up the chat box and type something in, and we'll be watching the chat messages as they come up here, and we'll catch your question or your comment, and when we get to a good stopping place, we'll cover it and answer your question the best we can. So I want to start out, the product we're going to be demonstrating today is the Nebraska Child Support Calculator, and it is a web-based product, and it's included as a free member benefit to anybody who pays the full membership dues to the Nebraska Bar Association. You can either get to it by going to its own website, nebraskachildsupportcalculator.com, or what I'm going to show today is signing on through the bar website, where you just go to the bar's main web page and you click on the link right on the front page to log into the Nebraska Child Support Calculator. Your username to log in is your bar number. Your password is the same password that you use to log into the members only section of the Nebraska Bar website. If you have a problem with your password, you can call the bar office, and either Elisa or Sam or I think Sarah can help you with your password and can get it reset. There's also, if you have an email address on file with the Bar Association, there's also a password reset tool that you can use online just to reset your password right away. So in this case, I've got my bar number, which is also a little bit of a disclosure of my age, and I've put my password in here previously, and so we're just going to click log in, and we're going to be away, ready to go. Once you log in, for the live folks here, I'm going to move the chat window for a second. Once you log in, all of the places you can go from where you're at are on the left-hand side is where the menu is on every single page. So you log in, you're initially taken to the main menu, and we're just going to dive right in and we're going to start a new calculation. You click on where it says child support form or click to run a new calculation. So that's what we're going to do. Now, I'm going to start with a very basic calculation, and I'm going to start with the assumption that the mom makes $3,000 per month, the dad makes $5,000 per month, and they have 2 kids. And so with a very basic calculation, you just type in your numbers, scroll down, find the children, select 2, and this should be all that you have to fill in. You just hit calculate and away you go. This is going to be a basic traditional custody calculation for 2 parties. And it's going to give you your, if the mom is paying support to the dad is going to receive $638 per month. If the dad is paying child support to the mom's going to receive $981 per month. Some of the other products out there ask you which parent has custody, and this particular one doesn't care. It'll give you the result for both. So I'm going to go back and I'm going to start to fill in some of the features here. The first thing is that not everybody that you're going to represent is going to know what income is on a monthly basis. And so if you have somebody that you don't know what their income is monthly, but you know they make $10 per hour, I'm going to make an adjustment here to change the mother's income to $10 per hour. And if I hit submit now, it's going to adjust the mother's income to $1,733.33 per month. So it's taking $10 per hour, it's adding it up to full-time employment, 2,080 hours per year, and then it's dividing that by 12 months. And you can do that with almost any cognizable pay period. If you know that somebody makes $100,000 per year, you can set it annually, you can set it biweekly, in which case it'll multiply it by 26 and then divide by 12 and so on. In this case here, I'm going to go back to monthly, and I'm going to put the mom back in at $3,000. Tax-free income is income that you're not paying tax on. So a lot of people will get either a tax-free auto reimbursement. If they're in the military, they may get a housing allowance or a BAS, a sustenance allowance. If they get some sort of perk from their employer that you're convinced should count. I think everybody's familiar with the pizza shop case where the kid lived above the pizza shop where he worked, and he got free rent and he got free pizza scraps. And a judge thought it would be a good idea to impute income to him based on the fair market value of the rent and the pizza scraps, and which in my opinion is bad law, but it's our law. So if you have that, you can include things like that in tax-free income. Tax-free income follows the same pay period as the gross taxable income. So if you put in gross taxable income on an annual basis, put in tax-free income on an annual basis. Now the next portion here is filing status, and to illustrate something here, I'm going to put both parties' incomes equal at $5,000 because I want to show you something. The filing statuses that I allow are single, married filing jointly, married filing separately, and head of household. And the guidelines require that you choose the filing status that is appropriate based on the facts. I'm here to tell you that you should almost never, ever, ever choose married filing jointly, and I'm going to show you why right here. And in fact, to illustrate that, I pretty much have to double the income. So these are two people here who now have the same gross income per month, $10,000. They're on the upper end of the income spectrum. I've put the mother in at married filing jointly. I've put the father in at single. And a lot of lawyers call me up and they say, well, the party is married and they're filing a joint tax return, so I should choose married filing jointly, right? Wrong answer. Because the married filing jointly tax brackets assume there's two taxpayers that are putting income into one pot. And so if you're choosing married filing jointly for one party, there's no allowance for their spouse to cause bracket creep when you're putting two incomes into one pot. So here, the dad pays $2,075 of federal income taxes every month as a single taxpayer. The mom pays $1,536 as a married filing jointly taxpayer. And so what this is doing is the tax brackets are, until you get up to about $80,000 per year, the married filing jointly tax brackets are exactly double that of the single tax brackets. And then what the Republicans would call the marriage penalty tax starts to kick in, and so then the tax brackets start to narrow as you're married, and they're not twice as wide as they are single. Yes?
One of the questions I had is that when you're putting down, the status of the person, are you talking about the status between the payor and the payee, or because we've had people who have a child support requirement, but they've remarried somebody else, so how do you list them?
You're talking about their status in terms of them vis-a-vis the United States federal government. And the question for those on the webinar is are we talking about the status between the parties, or are we talking about the status of the party in a vacuum? The only time you would ever use married filing jointly is if your client was a high wage earner and they were remarried and their new spouse had zero income. So think of a physician who remarries. That physician gets the benefit of having a new spouse, so now they're in a more favorable tax bracket because they get to do married filing jointly, but their spouse doesn't have any income. That's the only case where the facts would support using that. If they remarried and they had approximately equal income to their spouse and they were high income earners, it would be appropriate to use married filing separately. And I haven't done this yet, but we'll just try it.
You're talking about the new spouse, so not the one
correct.
who had the child.
Correct. So if I do one of these as single and one as married filing separately, I believe these incomes are high enough that the marriage tax penalty will show. Yeah, here it is. It's starting to kick in a little bit. I think it's somewhere in the $80,000 range. It changes every year because they index these things to inflation. But here in this case, I've got the father is single and the mother is married filing separately, and you can see that the mother is paying about $38 more in federal income tax on a monthly basis, and that's the marriage penalty tax starting to take its hold there. Okay, well, let's get back and let's put in some figures that are probably more in line with what we were going to do on a normal day. Head of household is pretty common for the custodial parent, even if they haven't been physically separated for 6 months during the year that the case is going on, because a custodial parent is going to claim head of household in future years, and so it seems appropriate. Most people don't realize this. A lot of tax preparers, if people separate, and they separate in, say, November, and then they go to tax preparers in February or March of the following years, a lot of tax preparers will just assume that if the mom's got the kids that they qualify as being head of household filing status. They don't. You have to be physically separated for the last 6 months of the tax year. So starting on July 1 and going forward, you have to be physically separated from your spouse in order to qualify as head of household if you're still married. Now, change the facts a little bit. If you're divorced in November, it doesn't matter how long you've been physically separated. The IRS considers you to have been an unmarried individual all year, and so you can do single or head of household, whatever applies, depending on whether you've got a qualified dependent. Yes, sir?
So 99% of the time we're going to have single, regardless of what a parent brings in their tax returns, whatever it is, like on child support calculation, 99% of the time you're either single or head of household.
Exactly.
Okay.
Exactly. Yeah, I include those. Thank you. For the benefit of those on the webinar, the question was just based on these factors that 99% of the time you're going to be choosing either single or head of household, depending on whether they've got the kids. And of course, you get into this, and the answer to that is yes. You get into this issue of you've got two parents who have joint custody of two kids, and you know, the sensible way to do that is for both of them to be head of household, and for one of them to take child number 1 as the qualifying dependent, and one of them to take child number 2 as the qualifying dependent. I've seen parents who are recalcitrant enough where the person who finds out that they've got an extra day says, no, they're both my qualifying dependents, I'm head of household, you're not. And under a strict interpretation of federal law, there's actually some support for that, but my experience has been that state court judges don't really see the humor in that, and they generally don't allow them to do that.
Before you go by, if you're going to answer this later, I'll hold the question, but when we have, seems to be a lot of prohaska computations coming up if they've been separated enough and they moved on to another relationship.
Yeah, I'll cover the prohaska calculations in a bit.
Okay, good.
Okay, next option here is whether the person is self-employed. Self-employment taxes simply double the amount of FICA, and then they do some other goofy stuff with above-the-line deductions. But the bottom line is if this person is a Schedule C taxpayer, you indicate that they are self-employed, and the calculator will take care of the rest. What it does is it mimics what would happen if they filed a Schedule SE on their tax return, where they're paying self-employment tax in addition to paying federal income tax, and then they're taking a deduction for half of that self-employment tax above the line. Up until this year, when I did my 2015 update, I didn't do the above-the-line deduction, and I didn't do the true treatment of the Schedule SE. I just doubled the FICA tax and called it a day. And I had some lawyers call me who pointed out that my calculator was different than the loss-off calculator, which was actually mimicking the Schedule SE. And although I felt I was on the right side of the issue, because the guidelines say you only take the standard deduction and nothing more, and there's all sorts of above-the-line deductions that we don't recognize, in the interest of kind of creating consistency for the user, I decided to change it, which brought mine in line with what the loss-off product does. Mine is still a couple of dollars off in terms of the net income from the loss-off product. Because we round, the child support number itself should be the same, but I'm a couple of bucks off in the income, and the only thing I figured out is that they don't fully walk it down when they're doing the Medicare portion of it. So, but I've checked my work frontwards and backwards, and mine's right. So. State income tax, there's a kill switch for both FICA and for state income tax, and you could have a situation where you would want to turn both of those off. A lot of folks that are in the military will declare their residency in a state that doesn't have income tax. Alaska doesn't have income tax, and there's a couple of others. And so if you're looking at a pay stub with no state income tax, then turn it off. If you're looking at a pay stub that has some other state's income tax, like Alabama or Texas or something like that, and you want me to rate their tax scales into my product, sorry, I'm not going to do that. They're close enough. FICA, there are certain people that aren't subject to FICA taxes, and generally those are going to be public employees that pay into some sort of public pension system. Omaha police officers, I think, are still exempt from FICA because they pay a greater amount into their own mandatory pension system, and you'll encounter a few of those along the way, so you can just turn it off. And then for exemptions, in this particular case, we have 2 kids, so we're going to split the exemptions 1 and 1. But if you had 3 kids, I'll change it to 3, and you're going to alternate that 3rd exemption. On my product, you can actually put 2.5 exemptions per parent. What that will do is whatever the exemption amount is in that particular year, last year it was $3,300, this year I think it's $3,400, it'll just multiply the exemption amount by the number of exemptions you put in there. And so if I do this here and hit calculate, it discloses right up in the header of the calculation what's going on. So the mom's head of household, she's got 2.5 exemptions, and she's not self-employed. Dad's single, 2.5 not self-employed. It's perfectly legitimate if you have parents that get exemptions for kids that aren't a component of this calculation. Maybe they're either paying support to them or maybe they're living in the household. And so I could add another exemption on the mom's side. Say the mom has a child from a prior relationship. It'll allow you to do that, but it's going to give you a warning before it does. So if I hit calculate here, it's going to say, please double check your numbers. The number of exemptions exceeds the total number of children and parents. And so then it asks you, okay, what do you want to do? Do you want to go back and change something, or do you want to just ignore it and run the calculation? So if I hit the ignore it and run the calculation, it's going to run it. It's going to do exactly as you ask it to do, but on the printed worksheet, it's going to print a disclaimer. And I do this so that anybody who looks at that worksheet knows something's a little out of whack here. So you may want, if an opposing counsel gives this to you and they've put in 16 exemptions for your client, you may want to ask them why they're doing that. And the answer is they're doing it so your client doesn't owe any federal income tax. So, okay, so we're going to get back to 2.5 exemptions apiece. Health insurance. I want to show you how some people kind of screw up the health insurance. And so to do that, I'm going to set the dad's pay to $100,000 per year. And I'm going to indicate that the amount of health insurance is $100 per month. Now, in the child support guidelines, you only get to deduct the amount of health insurance that is attributable to the children only. So if they're paying a family premium, you have to have your client go get the cost matrix from HR and take the family premium and then subtract what it would be for single, or subtract whatever the next highest premium would be to arrive at the net amount for the children. But in this case here, you'll notice that the health insurance has a selector, is it per pay period or is it per month? And so just to show you what happens if you're not paying attention, I'm going to leave it on $100 per pay period, and keep in mind this person has $100,000 per year of annual income. So when I hit calculate, you'll notice that the health insurance premium down here is only $8, because what it's done is it said that the pay period is a year and it's $100 per year. So in order to fix that, what I'm going to do is I'm going to set the health insurance to be $100 per month as opposed to per pay period. And now I'm going to hit calculate. And now it's going to track the health insurance correctly. And health insurance in our child support guidelines is prorated, which means that after the support is calculated, whoever doesn't have the health insurance pays their percentage share. And that's why it happens down at the bottom on line 11 of the worksheet. All right, let's talk about retirement now. The guidelines allow retirement contributions for a voluntary retirement plan for up to 4% of gross income. And really, as a convenience to the user, I wrote a feature that just automatically deducts 4% for everybody. So if you don't want a 4% deduction, you have to turn it off, and that's in this checkbox right here. If the checkbox is checked that says or 4%, it will ignore whatever you put in the box. So for instance, for this guy, I'm going to put $1 million for retirement, and I'm going to hit calculate. And you see his retirement contribution on line 2C is 4%. So whatever you put in the box is going to get ignored. It's going to get overridden with that 4%. And in fact, when you go back to the form, you see it's even recalculated that and put it in the box for me. So if I have a voluntary retirement contribution that's different than 4%, in this case, let's say he's only doing 2%, $2,000 per year. Now I uncheck the box, now I hit calculate, and now it's deducting only 2%. So if you have somebody who's not going to deduct any retirement at all, you have to both uncheck the box and you have to put 0.
What's the difference? I mean, why would you only have voluntary? So if you have a mandatory retirement, you don't get credit.
The question is, well, actually, I don't know what your question is, but let me answer what I think you meant to ask. The guidelines allow a deduction of up to 4% for a voluntary retirement, or they allow a deduction for 100% of it's a 4% for a voluntary retirement. It's dollar for dollar for a mandatory retirement. So if your mandatory retirement is, say, 11%, like I don't know what the police are doing these days. At one point it was 11%, at one point it was 13%. I don't know what it is now. But let's just say that the dad, in this case, is paying 13% of $100,000 into a mandatory retirement system. I'll just put in $13,000, uncheck the box, and now when I hit calculate, now you see over $1,000 per month is going into that retirement. But let's say that the person has let's say that they have an IRA, or even a simple or an SEP, one of those plans you can put $13,000 per year into, but it's completely voluntary on their part. Their employer doesn't require it. I don't care how much they put into it, they can only deduct 4% of their gross pay. That's what the guidelines say. So, is it unfair? I don't know. It's a policy choice that our Supreme Court has made. So let's go back into here, and I'm going to reset this back to 4% for both parties. Previously ordered support is something that's in our Supreme Court worksheet, and really, to properly include something in that box, it has to be a prior support order that's in another court case, either in Nebraska or in some other state. And that's just a straight deduction from income. There's nothing fancy about it. I'm going to skip over regular support for other children, because regular support for other children is probably best done as a prohaska calculation, which I have a separate feature for. And then the last box that you get to fill in is the other deductions box. And I included this box because there's a few things that there's the occasional little slip of case law that under some circumstances says that something may be subject to a deduction. Student loan payments or interest under Elsasser versus Fox, those are subject to being deducted under certain circumstances. I think there's a case out there somewhere that says union dues may be deductible in certain circumstances. Whatever you want, whatever argument you want to make to the court about something that should be deducted, under the new child support guidelines that have at least been published by the Supreme Court for comment, the cost of the health insurance premium for the payor themselves is going to be deductible. At least that's what's been proposed. And once the comments are in, we'll see whether they actually promulgate that as a new rule. But the other deductions box is there kind of as a flex field. It's like the reverse of the non-taxable income, so that you can add in whatever you want. The child tax credit is generally only subject to being taken by the custodial parent, but I basically just have a selector box so that you can decide how many kids are going to be claimable. So if you've got 3 kids and you're alternating the exemptions, then the custodial parent gets 1.5, because they're going to get 1 kid some years and 2 kids other years. So they're going to get 1.5 kids on average for the child tax credit. And so if we fill this in, and then I automatically apply in my configuration file the value of the child tax credit each year. It's been $1,000 per year for quite some time, but Congress has played with it every now and then. It's not guaranteed to be $1,000 into the future. All right, let's talk about joint physical custody. Joint physical custody just has a separate worksheet. It has worksheet 3. And all you have to do is you just check the box that says it's joint physical. You plug in the number of days for each parent. If you want it to be equal, it's 182.5. And hit calculate. And what's going to happen is off the bottom, first you're going to have your worksheet 1, then you're going to have your worksheet 4, which is the number of children, and then you're going to have your worksheet 3 for joint physical custody. What this is going to do is it is going to first determine what percentage of the year does each parent have, and then it's going to say, okay, how much does mom owe dad, how much does dad owe back to mom, how is it netted out between the two parents, and then all this stuff from line 10 on is prorating the health insurance. And all that it's doing is figuring out who owes whom for child support and then who owes whom for health insurance. And do you add or subtract? And that's what the second half of the worksheet does. On my product, if you have more than one child, just like you have a number of children calculation for worksheet 4, what I've decided to do is to run the worksheet 3 for joint physical one iteration as the children age out. So first you'll have your worksheet 3 for 3 kids, then right below that you'll have your worksheet 3 for 2 kids, then right below that you'll have your worksheet 3 for 1 child. If you use any other calculator that's out there on the market, you actually have to run the calculation 3 times because it'll only give you the worksheet 3 for the number of kids that are in there. So this will save you a little bit of time. So that's joint physical. That one's pretty easy. I'm going to uncheck that, and now let's talk about split custody. Oh, I should show you one more thing for joint physical. A lot of these parenting plans have one parent has the kids for 6 days out of 14, another parent has 8 days out of 14. And so if you're going to do that, it's 209 days and 156 days. And so if you hit calculate, then what's going to happen is it's the same worksheet 3, except instead of the parents having the child for 50% of the time, you see it's 57% and 43% approximately.
Can you print each configuration separately as you do it?
The question is, as it relates to printing, yeah, you can. And actually what will happen, assuming you're using a relatively modern web browser, each of those worksheets should print on a separate page. So there's built-in hidden page breaks between each worksheet. So again, if you're using a modern web browser, if you're using Internet Explorer version 5, I don't make any warranties about that.
On the question of the medical contribution to the health insurance payment, before you move on,
yeah.
A lot of the plans, when they say family, sometimes they have different definitions. Because if you're going to try and pull the kids out of there, you have to also pull the spouse out of there.
The question is, when you have family health insurance, what do you do if it's the kids and the spouse? I've always told people that if the choice is a choice between individual coverage and family coverage, then the cost for the kids is the difference between the two. Because if you want to insure your kids, that's how you do it. That's how it's packaged. If you happen to also get free coverage for your spouse or your second spouse or whatever, great, good for you. But the cost is the difference between family and individual.
Because typically whoever has the coverage is going to be required to cover the spouse for the 6 months after.
Yeah, typically judges order that, although that's not the law. The law is that the health insurance company is required to consider them to be married for 6 months, which means that whoever pays for it as if they're still spouses. Judges misinterpret that and say whoever happens to have the coverage should pay for the other spouse for 6 months, and they think that's the law. That's actually not the law. It's perfectly legitimate for a judge to say, husband's got the coverage, wife, you're going to stay on for 6 months, but wife, you're going to reimburse the husband for the cost of your coverage. It's at a reduced rate. You're on a group plan, and so it's a good deal. But
where do you find that language?
the language for that comes from the statute that talks about the finality of the decree, and it's 42-360 something. I couldn't tell you off the top of my head, but all you have to do is pull one of my divorce decrees and look at the second to last page, and it'll say the finality of this decree is determined by 42-360 whatever, and then it tracks that.
So the court say that that's the law, that's not correct.
Yeah, it's not the law that whoever was unlucky enough to be providing coverage on the day the divorce was filed gets to keep providing the coverage. The law is that the health insurance company is required to continue to give them the good deal. But how it's paid for is up to the court's discretion. Okay, let's talk about split custody. Split custody is when you have one child that is with parent A and one or more children that are with parent B. And so in this case, we're going to do a 2-for-1 split, and we're going to say 2 kids are with the mom, 1 kid is with the dad. Now, of course, this doesn't happen very often, or at least it's not supposed to. Judges don't like to split up kids, or so they say. until they decide to do it, in which case they just ignore that. So you're going to have your same worksheet 1, your same worksheet 4, but then you have worksheet 2, which I'm going to close my chat window here for a second, is a little bit of a mess. And in my system here, I put blanks that you can type in the name of each of the children, so we'll just say that we have Sophie and Jenny are with the mom, and Sam is with the dad. You don't really have to type in the kids' names, but I include a blank so that you can do it. So what we're really doing is we're taking that total monthly obligation, which is the, in this case, it's $2,328 for 3 kids. We're separating it out per kid, we're separating it out per parent, and then we're setting it off against each other, very similar to how we would do it with a joint custody calculation. So in this case, mom owes the dad $246, dad owes mom $1,059. It nets out to $812, and then the mom owes the dad a little bit back for health insurance because the dad's providing the health insurance coverage, and so it nets out to the dad pays the mom $781. Now, just because I don't know when you enter the data on this which kids are going to age out first, I don't have any way of spitting out these worksheet 2s to successfully deal with the children aging out. So if it just so happens that the mom has the 2 oldest, you've got to run it this way, then you've got to go back and you've got to run a 1-to-1 split, and then you've got to go out and run a calculation with just 1 kid where the dad's got custody of that kid. So unfortunately, that just goes with the territory here.
If you have a decree that's going to alternate, where mom has 2 kids this year, and they want to have 2 kids go with dad the next 2 years, will the system allow for that?
So the question is, you have a decree that alternates where it's 2 kids with mom and maybe 1 kid with dad this year, and then next year it's going to be 2 kids with dad and 1 kid with mom. You just have to run separate calculations for that. Although I would caution you that that decree probably has some problems in terms of being a conditional order. I mean, in a real strict sense, if the mere passage of time is all that it takes to trigger a certain kid from going from mom to dad's house, it's not technically a conditional order because we know what's going to operate when it's going to operate, but I think a judge would look at that and say that's going to be a very, very difficult order to sign when it comes to judging the best interest of that child a year from now. So I have had one where parties agreed to alternate a kid for a year, but they did that because the mom lived in Germany and the dad lived here. Mom was in the military, and they wanted to give the kid a 1-year experience living in Frankfurt, and so that's what they did. But in that case, you're going to have to just run multiple calculations. Okay, let's turn off split custody, and let's talk about a prohaska calculation. A prohaska calculation is what happens when one or both parents have subsequent children. And I'm not the fondest of the prohaska case, but it's a case that we've got that tells us one of possibly many permissible ways to do this. The prohaska opinion was a Court of Appeals opinion, and it affirmed a trial court decision that did it this way. And the prohaska opinion was very clear that this is not being done to the exclusion of other possible methods of calculating support, but that they were simply affirming what the trial court did in this manner as being not an abuse of discretion. So in that sense, the prohaska opinion is a safe harbor. If a trial judge does it this way, they can feel relatively safe that they're not going to get overturned. You could certainly try to convince a judge to do it a different way. There's the one thing that the prohaska opinion does say is that in any calculation for subsequent children, there has to be some sort of acknowledgement of the financial interdependency between the families. And so the ways that I've seen this done are what I call the Slovacek 2-step, the prohaska 3-step, and the child support enforcement 4-step in terms of how many calculations you run. So the 2-step calculation would be that you start by running a hypothetical calculation between the parent in this case who has the subsequent child or children and then the other parent of that case as if they were divorced and how much child support would be paid. And then you deduct that as regular support for other children in this case. The Prohaska 3-step is the exact same as the 2-step, except it starts with a calculation between the parties here. It then deducts the preliminary result as regular support in step 2, which is the hypothetical calculation. And then it deducts the result of the hypothetical calculation as regular support in step 3, which is back to being between the parties. And not to be outdone, our 4D offices with our friends at Child Support Enforcement do it as a 4-step calculation where it's a hypothetical, then between the parties, then another hypothetical, then between the parties again. And so I wanted to know, when I wrote this software, I wanted to know which one is really right. So I wrote my software to just keep running steps. I started with a 7-step calculation, and then I ran a 9-step calculation, then I ran a 10, and then an 11, and then a 12, because I wanted to know how many times can this pendulum vacillate back and forth between now and when you get to a result that's absolutely predictable. And what I found was that between a 2-step and a 3-step, there's some variance. Between a 3-step and a 4-step, there's some variance, but it's generally less than a couple of dollars. And between a 4-step, a 5-step, and a 6-step, the variance becomes less than $1, in which case it's no variance because we round, and then after that there's no variance at all. So these things come right into line. So I decided, even though I had the opportunity to kind of break some ground and come up with an argument why my calculation was better, I decided to just go with the Prohaska 3-step. So that's what I'm going to show you here. I'm going to assume that the dad here, who makes $100,000, has remarried, and the dad has one subsequent child with his new wife, and I'm going to assume that the new wife works outside the home but only earns $10 per hour. So all I have to do this is check the box for Prohaska that dad has subsequent children and hit calculate. And now the form turns itself on its head. That's lazy programming on my behalf, but that's what I did. And so now the top of the column says, it says you selected a Prohaska calculation, enter the information for the new spouses. So on the mother's side is now the father's spouse, in other words, the father's second wife. And so I'm going to put in hourly, $10 per hour, and this is exactly the same as the income for the original parents. She makes $10 per hour, and she's going to contribute 4% to retirement, and there's one child. And so I'm going to hit calculate. So here we have step 1. It's the preliminary calculation between the parties, mom at $3,000, dad at $100,000 per year, or $8,300 per month. And so preliminarily here, without a deduction for subsequent children, the dad's going to owe $1,557 in child support. So now we're going to scroll down to step 2. This is between the dad and the subsequent spouse. Oh, I screwed up. I didn't give the mom an exemption. I'm going to fix that here. I'm going to give her one exemption. In step 2 now, between the dad and the subsequent spouse, I've got $10 per hour for the mom. I've got $8,300 per month for the dad. And on line 2E, regular support for other children, I've got that deduction of $1,557, which is the result from step 1. So that's being carried forward into step 2. And so if these two divorced, and this guy was paying $1,557 to his first wife, he would pay $770 to his second wife. So now I go down to step 3, where I'm back to the income between the parties, $3,000 for the mom, $8,300 for the dad, and in regular support for other children, I'm deducting the $770, which is the result of step 2. The reason why there's pennies on this and there's not on step 2 is because in the end result, the last line 12 of any calculation, I round it. So I'm basically just ignoring the pennies there. So the end result here is that this Prohaska calculation reduces the dad's child support obligation from what would have been $1,557 per month without the deduction down to $1,383 per month. So having another child in the household, having another mouth to feed, which if he had divorced this person would cost him $770 per month, only reduces his support to spouse number 1 by about $180 per month. And that's why I think that Prohaska maybe isn't necessarily the best system out there in terms of doing an interdependent calculation, because it really does shortchange the subsequently born child. Go ahead.
That's only for the child that is the new child that is born between the new spouse, or what about stepchildren? Is that part of this?
So the question is, what about stepchildren? The deduction only kicks in for children that you have a legal obligation to support, which would be children that are your children, the party's child, or that the party has adopted. If you voluntarily adopt a child which attaches a legal duty of support, then you get a deduction. The other comment I need to make, though, is that under the child support guidelines, a duty to support subsequent children, whether they're born or adopted, is an affirmative defense. And it's not a reason for a decrease, but it's an affirmative defense to an increase. So the classic example is the mom sues the dad for an increase in child support. The dad's income is greatly increased since the time of the original divorce decree. The dad has subsequent children, and so the prohaska calculation, he's likely still going to pay an increased amount of support, but the prohaska calculation dampens it a little bit, so it's not as much of an increase as it otherwise would have been. Yeah, go ahead.
Yeah, he asked my question, but I just want one variation. I just want to make sure. Okay, so the only person that's going to get credit for other children is the payor. The payee doesn't get credit. She has 6 more children.
That's the question is the payor the only person who gets credit for subsequently born children? And the answer to that is no. You can deduct from the income of the payee a duty to support subsequently born children. You just check their box as having subsequent children under the prohaska function as well. And so let me demonstrate to you how that happens. I'm going to go back to edit the values, and I'm going to check that now the mom also has subsequently born children. I'm going to hit calculate. Now it's going to ask, okay, the father's spouse, how much does she make? Let's say that the mom married up, and the mom is married to somebody who makes $100,000 per year. And we're going to give this gentleman one exemption. Now what's going to happen is in your prohaska calculation, you're going to have 2 step 2s. You're going to have a step 2 for the mom's side and a step 2 for the dad's side. So here's your basic calculation between the parties. This was really fun to program, by the way, this particular feature. You have a basic calculation between the parties. It's the 1557 and the 771. Same step 1 as we had before. Now we have a step 2 hypothetical calculation between the mother and the current spouse. So see, here's the mom, and here's the second husband who's making $100,000 per year. So the mom's deduction is $328. Now here's the hypothetical calculation between the father and the spouse, and now you've got $10 per hour versus $100,000 per year, and his deduction is $770, same as it was before. And now on step 3, you'd have a deduction for the mother of $327, or $328 was rounded. And then you have the father with the deduction of $770. And so it is possible. Now you can question the fairness of the mom going out and having 6 more children with somebody else and getting that as a deduction from their income. It's kind of a round peg in the square hole because the guidelines say that it's only an affirmative defense to an increase. Well, what happens if the mom goes out and says, well, I had 6 more children, and now when you recalculate it, nothing else has changed, but I'm entitled to an increase based on that alone? I would think a judge would have a problem with that, but I've never seen that case happen.
I was told by a child support attorney just the other day that the only thing they're going to compute is the payer's children.
Yeah, but the child support attorney is not the judge. The judge gets to interpret the law. The child support attorney is just taking a position just like a litigator.
A stipulated agreement, and it will ultimately go to the judge, but so basically both sides can claim after-born children.
That's what the guidelines say. Both sides can claim it. Okay, we've got a couple of questions here from folks on the web. The first question is, what does this do with 4209 and 4218 calculations? Those are low-income calculations. And then the second question, since we're on the prohaska calculation already, the second question is, how is prohaska calculated if dad has a subsequent child with a different mom, but they're unmarried and dad lives outside the home? That is a tough issue because if they're unmarried and they don't live together, there's an argument that dad doesn't really have a legal duty to support that child until there's some sort of paternity decree or separation agreement or something like that. I've had touchy issues where that has to be negotiated, and I've had lawyers say we're not willing to recognize kind of a common law duty of support to what's an illegitimate child without a court order or without a marriage and they don't live together. But the guidelines don't provide a clear answer for how you handle that. Let's take out all this stuff about prohaska calculations, and I want to show you low income, and then I want to show you high income before we run out of time here. So we're going to undo the subsequent children, and we're going to go back to our 3,000 and 10,000. What I'm going to do is I'm going to take the father's income down to something that's going to put him below the poverty line for sure. So I'm going to take it down to $1,000 per month. We have two provisions of the guidelines that kick in when we have low income. We have 4218, which is the poverty line limitation, and then we have 4209, which is the minimum support. So if I've played my cards correctly here, this should get us to a minimum support case. So forgive me if I'm wrong about this. And I had him in at $1,000 per year, so let's set him in at $1,000 per month. Okay, so here we have the dad in at $1,000 per month of gross income. Because of how his exemptions are configured, he's not going to pay any federal or state tax. He's going to pay Social Security and Medicare, and when you deduct that, and then he contributes to retirement, because of course who doesn't? When you add up those deductions, $116 of deductions, that's going to put him below the poverty line, which I believe is $958 per month. It's right in the guidelines, whatever it is. So in this particular instance, since he's already below the poverty line, Section 4218 doesn't kick in at all, because you can't be ordered under that section to pay anything that would put you below the poverty line. So his adjusted share based on the poverty line is 0. So now we get to minimum support. His net monthly income is $883, and minimum support is either $50 or it's 10% of your net income, whichever is higher. So in this case, his net income is $883 per month. Minimum support is 10% of that, so under 4209, he's going to pay $88 per month. So now let's add something in. Let's make this a poverty line case, but not a minimum support case. And I think I have to make his income $1,200 to do that. Let's see. Nope, he's still in minimum support. This is an interesting one here. He's not below the poverty line, but in this case, minimum support would be more. So in this case, his net income is $1,060 per month. If you look at the poverty line, after you deduct the poverty line, he's got $79 left. So that would be his poverty line level. But 10% of his income is still more than that. So in this case, this would still be a minimum support case. He would pay $106 per month, which would put him slightly below the poverty line, but that's okay because it's 10%. So let's add another $100 to his income and see if we can get him up just slightly above the poverty line. There we are. So here in this case, if he was paying regular support, his support would be $380. But because his net monthly income is $1,148, he's just barely above the poverty line, so we're going to cut that down to $168 per month, which is just a little bit more than 10% of his net income. So that's the interaction of the guidelines with 4209 and 4218. But no discussion of the poverty line would be complete without a discussion of cash medical support, because you see that a lot of times in these 4D cases. And so in this case here, I'm also going to turn on a cash medical support deduction for the dad. And what I'm going to do is I'm going to boost the income up to about $1,500, and I think this will be enough to have cash medical support. Oops. You can't do cash medical support and health insurance, because if you have health insurance, there won't be any cash medical support. So I have to take the health insurance deduction out. Cash medical support is, we start with the proposition that it is 3% of the payor's gross monthly income, but it is reduced if the payment of cash medical support and child support would put the party below the poverty line. Our Supreme Court, after these guidelines were recommended by the Child Support Commission and essentially mandated by the federal government, which is a totally separate issue, but after the recommendation by the commission. The Supreme Court then decided that cash medical support would be prorated between the parents like health insurance. And that created a situation where in certain instances where you were close to the poverty line but not below the poverty line, you had a chicken and egg problem. In order to calculate child support, you needed to know what cash medical support was because it was prorated. In order to calculate cash medical support, you needed to know what child support was because you had to factor in that deduction before you got to the poverty line to see if it was going to be abated. And so I sat down with Bill McKenzie, who at the time was a county attorney, and now he's the new child support referee. And he and I came out with a solution to kind of break the infinite loop. And what we end up doing here, oh, I'm sorry, the poverty line's up to $981 per month now. $981 per month is the poverty line. So this is the kind of the proprietary worksheet that I came up with. And I'm going to close the chat window so the folks that are live can see this. So we have our gross monthly income is $1,500. 3% of that is $45. The net monthly income is $1,306, almost $1,307. And in this case, this person paying regular support, that would put them below the poverty line. And so even if we go with the 4,218 adjusted support, that takes them directly down to the poverty line, which means there's no money left to pay cash medical support. So in this particular instance, cash medical support would be zero. So let's boost up the guy's income a little bit more. Let's take him up to $1,800 per month. $1,800 per month still would be putting this person below the poverty line. So let's take him up to about, let's take him up to $2,000 per month and see if that does it. Okay, here we go. $2,000 per month. 3% is $60. The net monthly income is $1,680. After they pay the child support, you're left with $68 above the poverty line, which just happens to be just a little bit above that $60 cash medical support, so that's what his cash medical support number is. And then you can see back on worksheet 1, that's prorated between the parents. So the child support actually goes down by a few bucks because of the cash medical support obligation. All right, I want to talk about high income here for just a second. So we're just going to add a 0 to the dad's monthly income. Actually, we need to probably take it to $25,000 to show a difference. The guidelines have a safe harbor method of calculating child support in a high income situation. It's called 4-203C. And in that instance, we're going to take cash medical support out of the equation here. Under a 4-203C calculation, I'm going to close the chat window again. What you do is the guideline table only goes up to $15,000. Now I believe that under the proposed guidelines they're going to extend that out to $20,000, which is going to have the effect of taking $5,000 of income and turning it from being discretionary into mandatory in terms of paying support at the higher end of the spectrum. When net monthly income combined between the parties is greater than $15,000 per month, the support can be the same as what it is, $15,000 per month level, or in the court's discretion it can be greater. And 4-203C gives the court a safe harbor, which it can do, but I want to be clear, this is not a rebuttable presumption. There's no presumption at all about this. But if the court does it, it's not an abuse of discretion, which is why I call it a safe harbor. You take the additional amount that is earned above $15,000 per month. In the case of this calculation, you're talking about just shy of $2,500 because the net monthly income combined is about $17,500. And then you add on to the amount from the child support table 10% for 1, 2, or 3 children, and then it's a higher percent for 4, 5, or 6 children. I think it's like 12, 13, and 14% or something like that. So in this case, for 3 children, the table amount would be $3,295. That's if the parents had $15,000 together. There's your 10% of the net income above $15,000. There's the total support obligation. And then in this case, I haven't added health insurance in because I just backed out of the cash medical. But Dad would pay, on an adjusted basis, $3,023 based on $17,500 of net income. If you were just calculating it based on the maximum table amount here, which is found here on line 7, it would be $2,800. So in this case, having that extra $2,500 of net monthly income boosts the child support by about $200 per month. So that's high income. Let's back out of the high income. Well, let's just make it high but not really high and go with a basic support obligation here. I'll show you a couple of other things here. First is the permutation feature. Now, this is not an official Supreme Court form, but this can be kind of helpful if you've got disputes over what somebody actually makes, or even if you just want to show your client that the amount of income swing doesn't greatly affect the child support calculation. So here in the middle is the number that I entered. So $2,300 would be the dad's share of the obligation based on $15,000 for him and $3,000 for her. And then it starts out in $100 increments, so I can go up to $15,100, $15,200, $15,300, and so on. But when you're talking about income like this, I could actually boost the dads to $1,000 increments. And so now I've got the dad at $15,000, the dad at $16,000, and look at this. With the dad at $15,000, it's $2,310. Add another $1,000 to his monthly income, $12,000 per year. It goes from $2,310 up to $2,464. It's a difference of $154. Add another $1,000, it goes up to $2,603. And so, like I say, this isn't an official Supreme Court form, but it can be helpful in terms of figuring out, okay, how much of a fight is it really worth? And it was kind of fun to do. The other thing that you can do here is you can calculate the life insurance requirements. Some people want to have life insurance be included in their decree, and there's a matter of debate as to how appropriate this is. The divorce statute says, and if you look at Davis versus Davis, where Henry Davis was the party, the Supreme Court gives an analysis of the statute that says the court has jurisdiction to require security for payment of a child support or alimony obligation. But of course, then you have the equitable question of, well, how much credit should the dead parent get for Social Security death benefits that the children are going to get? I pass on that, and I just have a calculator that shows you what's the present value of this child support obligation going to be. And so you enter the month and year of each child's birth, starting with the oldest. So what I'm going to do is I'm going to say that the oldest was born in July of 1998, and then maybe the second oldest was born in October of 2001, and then the youngest was born in November of, say, 2011. We've got a heck of a spread between these kids. And I'm going to give it a 4% discount, which I think is reasonable. This is going to add up the number of months remaining at each level of this child support calculation as these kids age out. So for the father here, the father monthly amount of $2,310, for the oldest kid, he's got 28 months remaining until that kid ages out. 28 months at $2,300 per month is $64,000. Its present value down to $61,000. Then now when you're down to 2, the amount goes down to $2,048. He's got 39 months at that, $79,000 total. And you notice the present value is starting to cut into it at this point because you're starting 29 months in the future and you're going down from there. And the same thing for the last child, $1,480 per month, starting in month 70 or whatever it is, 69 or 70 for 121 months. It's a whopping $180,000, but with present value, since it starts so far in the future, present value is $117,000. If the dad was going to buy a life insurance policy today that could be invested once it pays out in a bank account bearing 4% interest, $250,000 would generate enough to pay out monthly these child support payments until the youngest child ages out, which would total $323,000. So it gives you kind of a bead for what the life insurance requirement could be. Whenever there's going to be a life insurance, I always insist, if I can get it in negotiations, that it be paid through a trust. I always insist that it be present valued because I philosophically don't believe that the death of a parent should be a windfall to the surviving parent. And sometimes I get that and sometimes I don't. So the last thing I should show you is the deviation worksheet. I added this based on a bunch of requests from people. All that the deviation worksheet does is it just calculates a straight deviation. So let's say that the dad is going to pay for soccer directly. I can type in my reason, and I can say that this is going to subtract $100 per month from the dad's child support obligation and hit calculate. Now it's going to give me my basic worksheet, and then it's going to give my deviation worksheet. So, and again, this is just something that sometimes the guidelines say you have to have a separate worksheet, it has to be signed by the judge and so forth, and this is my way of implementing that. I don't have a whole lot of people that use this, but I had some requests for it, so I added it. A word about using some of these features together. The deviation worksheet doesn't work with joint, it doesn't work with split. You're on your own, good luck. Joint and split don't work together. You're on your own, good luck. If you have a situation where you have joint and split, call me, and I'll give you the same advice that I give to every single lawyer. I have a proprietary worksheet. I'm not going to show it to you today. It's not a part of the child support guidelines. I'm not going to write my calculator to do it because my calculator is limited to things that are objectively supported by the law. And I don't want to have people churning out these worksheets acting like it's objectively supported and then having a case go up on appeal and having somebody say that, well, this product got it wrong. So I want this to be conservative and to handle only things where by running a calculation you can have a very high degree of assurance that this is supported by the law. But if you have a situation where you've got child number 1 is 50-50 between the parents and then child number 2 and child number 3 live with mom full time, call me and I'll give you my worksheet and I'll give you the same disclaimer, which is that there's no legal support for this at all. But it makes sense to me, and it's what I tell everybody. I'll tell your opposite lawyer on the other side of your case the same thing. If your judge calls, I'll tell your judge the same thing, but there's no legal support for it. So we'll pull the chat window up. It doesn't look like anybody else has any questions, and we are out of time. I know we're doing an EBDOCS presentation right now. I believe that for those of you who are online who want to do both, just stay online for the second hour, and we'll get going with EBDOCS. Yes?
The life insurance condition, is that considered legally as child support?
The question is life insurance considered to be legally child support? It's not taxable, if that's what you mean.
Well, from the standpoint, can somebody file bankruptcy on that?
I don't know whether that can be discharged in bankruptcy. I would guess, because the bankruptcy code doesn't draw a distinction between what's child support and what's not. The bankruptcy code draws a distinction between what's a domestic support obligation and what's not. And a domestic support obligation is an obligation that's owed to a former spouse, which is not assigned except if it's assigned to the state and is in the nature of support. So I think it would be a pretty easy conclusion for a bankruptcy court to draw that life insurance is in the nature of support, but I'm not a bankruptcy expert. I don't know. So I do know that when you are planning for bankruptcy in a divorce decree, the bankruptcy court is required to give legal effect, i.e. res judicata, to the factual findings made by the state court judge. But the bankruptcy court is required to draw its own legal conclusions. And so I always put factual findings in my divorce decree that says that, yeah, sure, the bankruptcy court can decide if this is a domestic support obligation, but I'm going to find, as a matter of fact, as being res judicata, that if this obligation isn't paid, that the mom and the kids are going to live in a cardboard box, and they're going to be on public assistance, and they're going to have to do this, and they're going to have to do this, and they're going to have to do this, and they're going to have to do this. And what I'm basically saying is, bankruptcy judge, I double dog dare you to reach a legal conclusion that this isn't a support obligation. You go ahead, draw your own legal conclusion, but you can't draw any other one, is what I do. Okay? Well, thank you all very much. I appreciate your attention.